Katie, having covered this for so long, what is your sense? What did you feel when you heard about the decision being rendered by the Colorado Supreme Court? And what's your sense as it goes up the ladder toward the Supreme Court, a court that has had more than a whiff of politics to it?
Yeah, so, when the decision came out, what was so interesting about it is that, again, it does not rely on the question of whether or not Donald Trump was going to be prosecuted for insurrection, whether or not he's charged with insurrection. It really goes back to a reading of the 14th Amendment that, historically was, after the Civil War, during the Reconstruction, what do we do about people who rose up against the United States who were not going to be prosecuted? It was to ban them from office. So when you think about what could happen when this goes to the Supreme Court, you have a series of justices, many of them conservative, many of them who would take a very literal reading of something like the 14th Amendment, and it becomes an interesting challenge for this court. On the one hand, I think many of the justices would not be inclined to rule on this question. They might want to rule on something narrow and technical. But at the same time, the Supreme Court is tasked with deciding the most consequential and most important legal questions, and this is one that squarely falls within an originalist reading that conservative justices would be inclined to take up in that manner. So I think it's going to be fascinating. It's very I could never predict what they will do, but it's hard for me to believe that they won't take this up.
Lisa, having understood that, when you look at the context of the 14th Amendment and the fact that it came into being because of the Civil War and the racial overtones and that they had split and now in terms of the Confederates. So that's one complexity this court has to deal with. But the other is the January 6th case of Jack Smith, which you've covered a lot and talked about a lot. And wouldn't, if they take a broader rather than the narrow view of deciding this, wouldn't they, even taking this on, help determine that Donald Trump is guilty of an insurrection? And how will that impact the case?
Well, what's interesting about the case, Rev, that you were referring to, the federal election interference case, is that there are no charges for insurrection or seditious conspiracy involved there. The conduct is largely the same, right, but the charges there are 3 conspiracy charges and 1 straight-up obstruction of an official proceeding charge. So depending on whether the Supreme Court takes the case, as Katie was discussing, but also how they decide it, what factual findings they affirm, it could or could not have some impact on the future of that January 6th case. But the bigger picture is that we may be going into a holiday season where our Supreme Court is not going to be asked to review 1 question relating to Donald Trump's future, but now 2, because Jack Smith has asked the court to prioritize and leapfrog the D.C. Circuit Court of Appeals and take on directly the question of whether President Trump is entitled to immunity in a criminal prosecution. Now, based on what the Trump campaign has said last night, we could be facing a second question to the Supreme Court. This Colorado Supreme Court ruling is appealable only to the U.S. Supreme Court, and the first 69-plus pages of this decision are not what's appealable. That's where they're discussing sort of preliminary questions of Colorado election law. What is appealable to the Supreme Court, though, is what Judge Luttig was describing, which is the holding that Section 3 applies to presidents and that it is self-executing, meaning it doesn't need legislation passed by Congress to disqualify someone. And in that, this court is sort of mimicking Judge Chutkan in her immunity decision, appealing to the justices with a straight-up, this is what the plain text says, this is what the structure of the Constitution, other provisions tell us, and this is what our history tells us. At the time of the ratification, this is what people said during the debate in the floor of Congress on ratification. I think all of those things show the Colorado Supreme Court, just like Tanya Chutkan, was very much thinking about these justices and how they will encounter these questions.
So a couple of questions. I mean, if the Supreme Court can't get to a decision for some reason, does this ruling hold? And Katie, in terms of timing, what are some of the issues here? And also, are there any other states that still have to rule on this? What are the implications of this?
Yeah, so in terms of timing, I think starting there is important. So the Colorado Supreme Court has given the Trump campaign basically until the new year to file an appeal. Of course they will. They're going to appeal this to the Supreme Court. At that time, I think it's the next day, Lisa, that the Colorado Supreme Court has to decide who goes on their ballot. So my guess is that that ruling will be filed quickly, the appeal will be filed quickly, and then we'll see Colorado act as soon as possible. But what this is all leading up to is whether or not we're going to see trials begin in the Trump cases by March. So one of the reasons why Jack Smith, as Lisa has said, has leapfrogged the D.C. Circuit and brought questions of immunity before the Supreme Court is he would really like to see these things settled so that case can begin in the spring as close to the date that the federal government had planned as possible. What's so interesting is we're seeing legal cases collide with the campaign. And we're seeing important dates in the campaign when we're going to decide who the Republican nominee is, when we're going to decide, what voters will be given as choices, directly at odds with all of these questions now before the Supreme Court. My guess is that the court is very cognizant of how political this is and how important it is, and will want to say whether or not they're going to take up these cases as soon as possible.